Hey there, I'm Liz Holmes, Associate Broker at the Rockland Organization. Could an employer require its employees to take the COVID-19 vaccine as a condition for returning to work? Answers to that and other legal questions coming up. Today, we are pleased to have with us Doug Rowe, a partner in the Labor and Employment Group at Sir Tilman Ballin. Doug's broad range of expertise includes claims alleging discrimination based upon race, sex, religion, national origin, age, and disability, as well as sexual harassment, wage and hour issues, labor arbitrations, and defense of employment-related claims under federal and state statutes.
Today, we're going to discuss the employment law considerations for returning to work, and also, what we've seen as essentially the claims that have been arising out of the pandemic. Employee morale in general is every employee, every employer, and every employee in every company is concerned about their health and safety. Employers are concerned about, getting the job done and profitability, but also, the health and safety issues. Those issues also potentially invoke the workers' compensation law if an employee does contract, the coronavirus in the workplace. You have those considerations. The hottest issue at this moment with respect to returning to work, which is to vaccinate or not to vaccinate. And this goes to the issue of whether employers can require their employees to vaccinate against COVID-19. So the answer is that employers are not required, but they can require their employees to vaccinate. The EEOC basically said, yes, employers can mandate that their employees vaccinate. And as part of the guidance, they also have addressed the issue of how employers should properly handle objections that employees may have against getting vaccinated. So, for example, if an employee has true objections based on a disability, the employer has to take that into account, has to engage in the interactive process with the employee to discuss whether there are some alternative measures against getting vaccinated. And then the employer would have to evaluate whether the employee is entitled to a reasonable accommodation of not being vaccinated. And if that employee is not vaccinated, how the employer can deal with that employee who's not going to be vaccinated against all the other employees who may be vaccinated. So again, as I said before, one of the potential reasonable accommodations there would be permitting that employee who has a true concern about being vaccinated. And when I say true concern, based on a disability, it's not just I'm fearful of what could happen to me. It has to be a viable concern based on a disability or a religious exception, by the way.
So, Doug, do you see any challenges to that if the employer is mandating that the vaccine be given to an employee? Do you see challenges coming from that in the future or at some point? Because the vaccine is not right now widely available. It's not as easy as walking down to CVS or to Walgreens, like the flu shot, and being able to obtain that. Do you think that there has to be some sort of time that goes by before an employer can mandate that, or do you think there's a buy-in that has to happen from the employees in order for this to happen?
The difficulty of mandating that employees are vaccinated is that every state has a different rollout period. So we all know in New York, not everybody, there's different phases to being able to receive the vaccine. So if an employer decides every employee has to be vaccinated, well, it's not immediate. I mean, it may be, certain employees this month, certain other employees next month. I mean, I'm not even sure what the schedule is as far as the rollout for employees being vaccinated. But again, it's not all going to happen at the same time just because of every state's rollout plan for getting vaccinated. So first of all, that's a practical challenge.
Another question that I have is how do you balance employee privacy with public health and safety concerns? So there are a number of protocols that businesses are taking as they go back to work. I've actually seen them. I know in our office when we go in, someone uses a thermometer. They take your temperature. Some of them, when you're walking into a business, you're scanned. So if you have an employee who says, this is somewhat invasive, even though it's it's thermal and it's being, zapped at your head, is that something that is permissible?
Yes. So the answer is yes, it's permissible. And the EEOC, again, the U.S. Equal Employment Opportunity Commission, has specifically stated that body temperature checks are permissible and are not deemed to be a medical screening under the Americans with Disabilities Act, which is prohibited under the ADA. So therefore, body temperature checks are permissible. And again, it makes sense, and it's protecting the workplace overall. And, the rights of the employer under that scenario, trumps the employee rights to privacy. And by the way, let's remember, we've all heard about invasion of privacy claims, but that really doesn't exist in the workplace in New York State. It's still better for employers to have a written policy as far as what they intend to do to protect the workplace. It's always better for employers with respect to employees' perceived right to privacy to let an employee know that they'll be monitoring their emails and monitoring their telephone, usage and whatever else with respect to employees' perceived right of privacy. But again, employees don't have necessarily have the right of privacy. But we're in a different world now. COVID-19 has really not changed the playing field, but there's a perception that it has. One of the issues that comes up in the invasion of privacy context as well is that if an employee is actually tests positive, what does an employer do? What are the employer's obligations? So because of the employee's rights to privacy and confidentiality, the employer in that case should disclose to other employees that somebody has tested positive, not to disclose who the employee is that tested positive, and then determine who the positive tested employee has been around in the workplace, and then the employer can deal with, whether there should be concerns for any other employees as well. So that's really, there is a confidentiality requirement, as I said, and that's the best way to handle it, which is not to disclose the identity of the employee who tested positive.
Okay.
Yep.
And the CDC has issued guidelines in terms of who is at higher risk for exposure to COVID-19. That includes individuals who are over the age of 65, pregnant women, other individuals with underlying health conditions such as obesity, diabetes. The list goes on and on. The question is whether or not an employer can ask one of those high-risk individuals, persons age 65 or someone who is pregnant, to remain at home simply because they are at greater risk. Are they allowed to do that under the law?
They're not.
Okay.
They're not. It's the employee's right. I understand why an employer would want an employer in that case would be hiding behind their outward concern about towards an older employee or a pregnant employee. But it's not up to the employer to make that decision. It's up to the employee to decide whether they're fearful based upon um, their being a vulnerable employee, so to speak, and whether they want to take a leave of absence or work from home or request some other accommodation. The EEOC also came out with regulations specifically on this issue, in the early fall as well.
Okay.
Yep.
And Doug, just, one final question. It could be sort of, pretty broad here, but are there any other duties, liabilities, or legal issues that an employer should be considering as they return to work? And again, I know that's pretty broad, and you did cover some of that in the beginning, but if you could touch on any other risks, liabilities that employers should think about as they return to the workplace.
Okay, well, the whole idea of returning to the workplace we've been talking about returning to the workplace for quite a while. We've been speaking about that since the changes. Originally businesses closed down except for essential businesses, and then that changed, and then there was some, then the state permitted companies to reopen. So we've been dealing with these return to work issues for quite a while. So this has been an evolving issue, but returning to work issues right now do not necessarily involve solely the physical return to work. One of the issues with working from home is employers are concerned that they're not necessarily getting the same productivity, and maybe they're not. And there is software now that exists that enable employers to track their employees' work. There's software that actually enables an employer to actually see what the employee is doing at any given time, what's on the employee's screen at that time. So that's a concern to employers, but that can be dealt with. One of the issues that we've been involved in is helping employers create work from home policies, so the employees will understand what their rights and obligations are. So I'll give you an example of what can come up on work from home issues. So employees, as you know, are entitled to be paid for all their work time. If an employee has a schedule to work 9 to 5, that's what the employee is going to be paid for on an hourly basis. But New York State, for example, has a requirement that employers provide their employees with at least 30-minute meal period every day. So the employers have to remind the employees that they have to take their meal period, that it's mandatory. When employees work from home, there could be a tendency for employees to take breaks whenever they want, because as long as they get the work done for that day, they'll be fine. But what happens there is how is an employer able to track the employee's time? And remember that employees are entitled to time and a half for all work over 40 for the week. So if all of a sudden the employee is working at night and on weekends, how does an employer really know how many hours that employee worked? So the employer by not setting a schedule for that employee is potentially at risk for an unpaid overtime claim.
Okay.
Okay.
All right, Doug, I think that's all we have time for today. I just want to thank you again for joining me, and I hope that we'll be able to speak with you again.
Sure. Thank you.
All right. Thanks again, Doug.
Sure.
Take care. Bye-bye.